Welcome, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep. And due to a festival in my neighborhood, I'm doing this recording outside on my phone, but hopefully you can all hear me. So I'm going to talk about some issues that students wanted to learn about today. And I'll start from the top. So the first issue is um, permissive and compulsory counterclaim difference. Okay. So if a counterclaim is from the same transaction or occurrence, it's going to be compulsory. Otherwise, it would be permissive. So if A sues B, then and it's over, let's say, a contract dispute, and B has a counterclaim arising from the same contract, that would be a compulsory counterclaim, meaning that B has to bring that up in that proceeding, or it'll be precluded from a later proceeding. Now, if A sues B over a contract claim and B has a suit against A that's from a car accident or something, that's permissive. They could bring it up now because it's the same parties and, we're all here. Why don't we just put everything on the table? But you don't have to. It's a permissive counterclaim, which means it doesn't have to be brought. So compulsory counterclaims arise from the same transaction or occurrence. And if they're not brought, then they're going to be precluded. Try to distinguish counterclaims from cross claims. Counterclaims are if the plaintiff sues the defendant will have a counterclaim against the plaintiff. A cross claim would be if a plaintiff sues two defendants, A sues B and C, and B has a claim against C, they're on the same side in relation to the plaintiff, so that'd be a cross claim. So cross claims, if you think about like a V in the middle, A, V, B, cross claims are on the same side of the V. A, V, B, and C. A cross claim would be between B and C, whereas a counterclaim would be across the V. So if A sues B, A, V, B, then B would have a counterclaim against A. Remember that counterclaims that arise from the same transaction or occurrence are compulsory, and otherwise they're permissive. Cross claims are always permissive. You don't ever have to bring a cross claim. You could either bring it in that proceeding or you could bring it in a different proceeding. Okay, so let's see what the very next question is. The different types of insanity tests. Okay, so there's four types of insanity defenses. There's McNaughton, there's irresistible impulse, there's Durham, and then there's the model penal code. The McNaughton test means that the person couldn't tell the difference between right and wrong. So classic example is they thought they were squeezing a lemon, but they were actually squeezing someone's neck, right? They were choking them. They were unable to differentiate between right and wrong would be the McNaughton test. The irresistible impulse test means that it was a reaction that they couldn't resist, right? It was an impulse. So if it's an impulse that you couldn't resist, it's an irresistible impulse. And if it's a situation where you can't tell the difference between right and wrong, then that would be a McNaughton. Now, the model penal code allows for either of those two scenarios, either the irresistible impulse test or the McNaughton test. So if it's either that they couldn't tell the difference between right and wrong, or that it was an impulse that they couldn't resist, then under the model penal code, that insane defense will be recognized. The Durham test is the but-for test. So it means that but for their insanity, the act would not have occurred. So the act was a product of their mental defect. So think of the but-for test with Durham. Think of the inability to distinguish right from wrong for McNaughton. Think of the compulsive irresistible impulse with the irresistible impulse test, and then recognize that the model penal code is either the irresistible impulse test or the McNaughton test, but it won't be the Durham test, right? Okay, so the next question is about mimic for evidence. So mimic stands for motive, intent, mistake or lack of mistake, identity, or common scheme or plan. So typically we're not going to allow prior bad acts to come in to show propensity to commit a crime. Like for instance, Susie is on she's been accused of speeding, right? We can't bring in evidence that she's sped, got a speeding ticket a year ago to show that she likely was speeding today, right? That would just be an improper um, character evidence that's it's a prior bad act that's coming in to show propensity, and we don't allow that. But what we do allow is evidence to come in for any other purpose except for propensity. So if we're showing a motive or identity or mistake or lack of mistake or a, a common scheme or plan, right? Um, or intent, these would all be things that we would be allowed to bring in. The easiest one to think of is identity, right? So if there is a robbery and the person who committed the robbery had a gun that had a red nose, right? A red nose on the gun. And we're bringing in evidence that Tommy has robbed banks 3 times before using a red nose gun. Well, then we could bring it in to show that it was likely Tommy who did this robbery because of the same identity of the red nose gun, right? So, identity is one example. Another example is common scheme or plan. Like, uh, if someone has stolen merchandise from a store, and the way that they've done it is by switching the tags, taking merchandise that has an expensive tag and switching it for merchandise that has an inexpensive tag, and then paying for the inexpensive tag. And that's exactly what happened on this occurrence. Then we could bring that evidence in to show common scheme or plan that the way you did it was the same. So it was likely you who did it. Or motive or intent, right? Like, can we bring in if Tommy is claiming self-defense in a shooting against his father, can we bring in evidence that they got in an argument the day before? The answer is yes, to show that he had a motive, right? They were in an argument and now he shot him, um, you know, based off of the argument, not based on self-defense. So it would show a motive or an intent. Um, Mistake or lack of mistake, like, um, an accountant is saying that he didn't commit fraud, he just made a honest mistake. Can we bring in evidence that he's done this same accounting um, thing multiple times in the past to show, yes, it was the absence of mistake, you didn't make a mistake this time, you have, and you have it, so we're going to bring in an mistake. The in circumstances really come in prove that the person, was the person who did the crime or the bat or whatever they're being accused of, because we're not bringing it just to show propensity based on previous occurrence. We're bringing it to show a motive, an intent, a mistake, a lack of mistake, an identity, a common scheme or plan, a modus operandi, if you will. These are different reasons that um, prior bad acts could come in, not to show propensity, but to show that it's, one of those things. Anything else but propensity, basically. And again, mimic is a good mnemonic. Motive, intent, mistake, lack of mistake, identity, or common scheme or plan. Um, all right, statutory versus equitable redemption. A good, easy way to distinguish and memorize the difference is that E comes before S in the alphabet. So the equitable right of redemption comes before the statutory right of redemption. Equitable right of redemption means in a mortgage situation, if there's a foreclosure means that we are going to sell the property in order to pay back the mortgagee, right? So if the mortgagee institutes a foreclosure action, it's not like the sale is going to happen tomorrow. You're going to have to um, have a certain time period when the sale will occur. So every jurisdiction recognizes an equitable right of redemption, and you can't even contract away from this. That would be a clog on the equitable right of redemption. You have to allow for an equitable right of redemption, which gives the mortgagor the option to come up with the money and buy back the property before the sale of the home. The statutory right of redemption is only allowable if provided for in the jurisdiction. Usually, if a jurisdiction allows for statutory right of redemption, it will be a 30-day period where up to 30 days or however long is, you know, however long is allowed via the statute, they can redeem the property. So, the mortgagor defaults, the mortgagee institutes a foreclosure action, and then the house is actually sold. Well, for a certain period after the sale of the home, they could exercise that statutory right of redemption if it's provided by statute. It's not guaranteed that there'll be a statutory right of redemption. So think about the equitable right of redemption coming before the foreclosure sale, but the statutory right of redemption coming after the foreclosure sale. And a good way to remember that, like I said, is E comes before S in the dictionary. Also, a good way of thinking about that right of redemption. I used to make a lot of references to these movies, but then they became so old that I stopped. But fortunately, they made a brand new Happy Gilmore that just came out on Netflix with Bad Bunny in it. And if you remember the original Happy Gilmore, that was the whole point of the movie. Happy was playing golf so he could come up with the money to buy back his grandmother's house because it was up for foreclosure. So he was trying to exercise his equitable right of redemption. And then he even went to the foreclosure sale and tried to buy it right then and there. If he would have done it after the sale, it would have been a statutory right of redemption. But that's what redemption is going to mean in in real property. And you also have those same redemption rights when it comes to secured transactions. I tell my students this: those who do secured transactions or commercial paper, you can think of them very closely to how you think about mortgages. Like a secured transaction is a loan, right? That is secured by some sort of collateral, whether it be tangible collateral like inventory, equipment, consumer goods or farm products, or intangible collateral like accounts receivable or you know uh, an IP or patent rights or something like that. But in either case, um, it's just like a mortgage where the property is the collateral in a mortgage agreement. In a secure transaction agreement, the collateral would be some sort of tangible or intangible good, but it's very similar in how they operate. There will be some sort of right of redemption that could occur, you know, after the sale process has begun. Claim preclusion and issue preclusion. Okay, so students saying that there's a question where the first case was a plaintiff against a truck driver, the truck driver won, and the second case was a plaintiff against a company that owned the truck. So in that case, we probably think of claim preclusion. And the reason why is because the truck driver and the company that employs the truck are in privy with each other. So there are instances where um, a new party can essentially stand in the shoes of the original party and assert preclusion. For claim preclusion, the most common example of this is an employer and employee situation. So in that scenario, the truck driver and then the company who employed the truck driver or vice versa are in privy with each other, and they actually constitute the same party when it comes to claim preclusion. For issue preclusion, the type of privy that you typically see is a subsequent landowner. So A and B have a case against each other, and you know, A prevails in the issue of whether they have an easement over B's property, and then A sells the property to C. Well, now C is considered a privy of A and can stand in the shoes of A and assert that issue preclusion as this essentially the same party. So that's something to think about. Privy when it comes to claim preclusion and issue preclusion. Privies for claim preclusion are usually employer employees, and privy when it comes to issue preclusion are typically subsequent landowners. Now you'll remember that claim preclusion, in order for it to be asserted, it always has to be the same party or they're privy. And think of a privy as the same party. Whereas issue preclusion is typically the same party unless the jurisdiction provides for non-mutual issue preclusion. If the facts tell you that the jurisdiction provides for non-mutual or allows for non-mutual issue preclusion, then it could be a new party that could assert the issue preclusion. Whereas claim preclusion always needs to be the same parties and the same configuration, meaning A versus B, A prevails. Now A versus B, A versus B, A loses the case. Now A wants to sue B again. No, because A is precluded. But if it's A versus B and A loses and now B tries to sue A, well, that's going to be okay because that's not the same configuration, right? They switched it from plaintiff to defendant. So they could kind of trick you on that. So claim preclusion is the same parties, same configuration. Issue preclusion, it's an issue that's been actually litigated, and it is usually the same parties unless the jurisdiction provides for non-mutual issue preclusion. Remember, issue preclusion is more narrow. It's the actual issue that was litigated, whereas claim preclusion is the entire claim. Um, you'll see issue preclusion questions being tough if they say there was a general verdict or a special verdict or there was an admission, right? If it's a general verdict or an admission, or let's say it was voluntarily dismissed, the issue hasn't been actually litigated. So in those circumstances, issue preclusion would not apply. Claim preclusion has to be a final judgment on the merits. That just means it has to be complete. It could be, two voluntary dismissals will constitute claim preclusion because, the claim has been dismissed and cannot be brought again. Failure to bring a compulsory counterclaim would lead to claim preclusion because now that claim cannot be brought again. Or more commonly, just a final judgment on the merits where A has prevailed or has lost their case against B, that would lead to claim preclusion because it's a final judgment on the merits. So remember, certain things have the effect of final judgments on the merits, like, an involuntary dismissal with prejudice, or two voluntary dismissals, or failure to bring a compulsory counterclaim. Those would all lead to claim preclusion. Um, there's some vocabulary with preclusion that I think is good to know. Offensive versus defensive. Offensive preclusion is when the plaintiff is trying to assert the preclusive effect. Defensive preclusion is when the defendant is trying to assert the preclusive effect. And then there's the concept of a claim being barred or a claim merging. If the plaintiff prevails in the original action, then we say that the claim has merged. If the defendant prevails in the original proceeding, then we say that the claim has been barred. So, those are some vocabulary words that you could think about with preclusion: offensive versus defensive, offensive like a sword, defensive like a shield. Merged versus barred. Merged is when the plaintiff prevails. Barred is when the defendant prevails. And then mutual versus non-mutual. Mutual means it has to be the same parties, where non-mutual means that it could be a new party. Another question that arises with preclusion is is preclusion, especially if it's diversity case, is that a procedural or a substantive issue? So the answer is it's procedural. Preclusion is a procedural issue, just like, transfer venue or um, order of the witnesses. But it's a little bit complicated because the federal um, common law interpretation of preclusion is that we will apply the preclusive effect of the first court in which the case was filed. So if it's a federal case, let's say it's a federal question and it's filed in federal court, and that federal court, allows for non-mutual issue preclusion or whatever, you'll allow for non-mutual issue preclusion in the second court because you apply the preclusive effect of the first court where it was filed. If it's a diversity case and it was filed in state A court and now we're trying to refile in state B court, we're going to look to the preclusive effect of state A court. You always look for the preclusive effect of the first court where the case was filed, where judgment was entered. But it is a procedural issue, but the interpretation is applying the preclusive effect of the first court where it was filed. So claim preclusion, issue preclusion can be tough, but the question we're particularly about the privity when it comes to preclusion. Think of a subsequent landowner as privity for issue preclusion, and think of a employer-employee relationship as privity for claim preclusion. The next question is, when does evidence come in for impeachment and substantive purposes? Well, it depends. It depends on the evidence. I think the toughest question is going to be a prior inconsistent statement. remember that prior inconsistent statements come in for impeachment purposes. But if that prior inconsistent statement was made under oath, then we could also bring it in substantively as well, right? So prior inconsistent statements come in for impeachment purposes, but if they're made under oath, then they could come in substantively as well. Prior inconsistent statements are a little bit more difficult in criminal cases because there has to be some corroboration and the opportunity, to subject the person who made the prior inconsistent statement to cross-examination. In general, prior inconsistent statements are exemptions to hearsay. So think of party opponent admissions, think of statements of identification after perception, and prior consistent statements, and party opponent admissions. So party opponent admissions, prior inconsistent statements, prior consistent statements, and statements of identification after perception, those are all exemptions to hearsay at the federal level. If you're only taking a Florida exam, they don't do exemptions in Florida. They're all exceptions. So those would be exceptions to the hearsay rule. Important to note that party opponent admissions are different than statements against interest, because statements against interest require unavailability of the declarant. There's certain hearsay exceptions that require unavailability of the declarant. Those would be statements against interest, former testimony, dying declarations, forfeiture statements, so statements that are made in procuring the unavailability of the declarant, and then family records. Those will all require unavailability of the declarant. Whereas the other hearsay exceptions, business records or let's say excited utterance, all those types of hearsay exceptions don't require unavailability. Unavailability is what they say immaterial. It doesn't matter if they're available or unavailable. So, really look out for that prior inconsistent statement. If it's made under oath, then it needs to be, then it can come in substantively and for impeachment purposes. Otherwise, it's just going to come in for impeachment purposes. Standards of review, abuse of discretion, de novo, and clearly erroneous. So abuse of discretion comes in for evidentiary rulings, whether or not we should have allowed this evidence to reach the jury. So whether something was hearsay or not, whether a conviction should have come in, whether confession should have come in, whether an expert should have been qualified as an expert to give expert testimony. Anything that's related to admissibility will be reviewed under the abuse of discretion standard. De novo review is for legal questions, questions of law, whether the standard of proof was, let's say, beyond a reasonable doubt or a preponderance of evidence, or whether, assault was an attempted battery or just a general intent crime, whether a child will be held to the standard of care of an ordinarily prudent child, or whether an adult, because they're doing an adult-like activity, right? Be reviewed for the very first time. And then clearly erroneous or plain error, those are coming in for findings of fact, right? Like finding of facts by a jury is a plain error review, and by a judge is a clearly erroneous standard. So as long as they're not, as long as they're not clearly erroneous or plain errors, they're going to be considered harmless errors, and it wouldn't give rise to, overturning the decision. So when you're thinking of standards of review, think of abuse of discretion for evidentiary rulings. Think of clearly erroneous or plain error for findings of fact, right? Whether Tommy was in Georgia on the day of the alleged crime, or whether the car was going 90 miles per hour or 100 miles per hour, right? Those are going to be clearly erroneous or plain error review. And then de novo review is for questions of law, legal standards, and, on appeal, we'll be looking at them for the very first time. Someone said trust and family law. I mean, uh, those are essay subjects on the UBE and in Florida. Um, a good mnemonic I have for family law is JV pieced, MJV pieced, let's say. M is for modification. The J is for jurisdiction, subject matter and personal jurisdiction, typically the 6-month rule under the UCCJEA. The V is for venue, right? Again, where the parties have lived for the last 6 months. P is for parenting plan. E is for equitable distribution. A is for alimony. C is for child support. And then D is for divorce or dissolution, right? You kind of just want to methodically go through those pieces of a family law essay: jurisdiction, venue, parenting plan, equitable distribution, or if it's a UBE test and they're talking about, you know, uh, community property or marital distribution, whatever the statute says, and then alimony, child support, and divorce or dissolution. A divorce versus an annulment is as if the marriage never occurred. A divorce is ending the marriage. So, think about an annulment almost like a rescission of the contract, whereas a divorce is more like, expectation damages, where we'll move forward with the divorce proceeding. And understand the exclusive continuing jurisdiction rule, where whatever court originally ordered the final marital settlement will have exclusive continuing jurisdiction to retain any new matters, any modifications or things like that if there's a significant change in circumstances. Marriage questions are typically best interest of the child. You cannot waive child support in a prenuptial agreement, but you could waive alimony. And then for trusts, trust, think about like the settler of a trust having capacity and intent and trust race and ascertainable beneficiaries, and different types of trust: revocable versus irrevocable, inter vivos, discretionary versus mandatory, spendthrift provisions, which can be pierced by child support, alimony, and taxes. Um, you know, when you're thinking of a trust, you're thinking about the interests of the settler. Like, would the settler have wanted this to happen this way or not? Right. The hallmark of trust modification and revocation is settler intent. The trustee is who manages the trust, and a trust will not fail for want of a trustee. The court can just appoint a new trust, right? Trusts are set up for the benefit of the beneficiaries and to conform with the wishes of the settler. Um, Cypres doctrine is that we will, if a trust is left to a charity and that charity no longer exists, then we can designate another similar charity that would again reflect the wishes of the settler. Um, you know, an inter vivos trust is made during the lifetime, where a testamentary trust is created upon death, usually in a will or something like that. A totem trust is a pour over trust where it's a payable on death account. So, an account will pay a particular person upon their death. Trust questions can be tough. Family law questions can be tough, and wills certainly are tough on Florida and on the UBE. We did a wills essay for the UBE where they distinguish between a beneficiary, an heir, and a issue. An issue is like your prodigy, like your progeny, like your son, your daughter, your grandchild, your great grandchild. An heir is someone who would take intestate, and then a beneficiary is someone who is designated in your will to take from the instrument. So there's some thoughts about wills. One thing that they test on the MBE a lot is what will prevail between a JTROS and a will. So if A and B have a joint tenancy with right of survivorship, right, A and B, and then A leaves their interest in the property to C, well, A dies. Who's going to take the property? Would it be B or C? The answer is B here because a JTROS prevails over a will. Similarly, a life insurance designation will prevail over a will, right? So if you have a life insurance policy and you leave your proceeds to B in the policy, and then in your will you say, I want the life insurance proceeds to go to C, you're going to look at the life insurance policy itself. That'll be determinative. Um, Before recording, a student asked, but what about a divorce? A divorce will void any distribution made to the divorced spouse, whether it's via will or life insurance. A divorce is kind of like they're legally no longer existent, and they're not going to take in any way. Remember the concept of lapse, where if a gift is left to a beneficiary and that beneficiary predeceases the decedent, the gift will lapse, meaning it will revert back into the residuary estate. Unless there's an anti-lapse statute, which would say that the person who was left the gift, their family, their lineal heirs could take in their place. You got to see if the jurisdiction has an anti-lapse statute. In the MBE, if they don't tell you there's an anti-lapse statute, then the gift will lapse. In Florida, for instance, there is an anti-lapse statute which allows any lineal descendant of the grandparent to take. So that pretty much means any family member before it will escheat to the state itself. So someone asked me predictions for what they'll test on Florida multiple choice. I mean, I'm not a gambling person, but I'm very mathematical. A lot of people are using AI and Chat GPT, usually, honestly, to get dumber in 2026, but don't at me about that. But if you asked AI, you asked me, or you asked the world's greatest gambler for Florida multiple choice, they would all say the same thing. It's very mathematically clear that the most likely combination for Florida multiple choice disadministration would be procedure, always tested, judicial, civil, and criminal procedure, then evidence, and then business entities, including corporations, partnerships, secure transactions, and commercial paper. That would leave wills and trusts off of the exam. They've never, not tested business entities back to back since the new format, and it wasn't tested the last time, which is why it would be likely to be tested this time. They're certainly going to test procedure, and then between evidence and wills and trusts have been tested 2 times in a row. And since they've made the change, they haven't ever tested it 3 times in a row. So, very, very strictly mathematically speaking, that is the highest likelihood. But if you think about the mathematically speaking, everything on the test, all those subjects are more than 50% likely to be tested. So even though that's the most likely combination, it's still more likely true than not that wills and trusts will be tested from a mathematical perspective. But the most likely combination, higher than maybe any other percentage, would be that combination of procedure, evidence, and business entities, including commercial paper, secure transactions, corporations, and partnerships. If evidence is tested, it's interesting. Evidence is 30 questions of evidence. Whereas if wills and trusts are tested, it's probably 20 wills, 10 trusts. If business entities is tested, it's probably 10 corporations, 10 partnerships, 5 commercial paper, 5 secured transactions. Which means that if evidence is going to be tested, which I think it is likely to be tested, it's tested very thoroughly, 30 evidence questions. So I would definitely study the distinctions between Florida and federal evidence. I wouldn't recommend not studying Florida wills and trusts because I said it's not part of the most likely combination. Because if it is tested, it's a tough subject and you want to do well on it. Let's see. So tips when it comes to answering questions regarding affirmative defenses and shifting the burden to the defendant. Okay, so in criminal law, criminal procedure, the defendant has the right to a presumption of innocence, meaning that in order to be found guilty, the prosecution needs to prove all elements of the crime beyond a reasonable doubt, beyond the shadow of a reasonable doubt. So elements of the crime of murder include, did he actually do the killing? So if, someone has been missing for 10 years in a criminal case, we cannot presume they're dead. You have to actually show me the body, right? I always tell people, the husband's not dead. The husband is in Tijuana. He ran away, right? In civil cases, you could make a presumption. A lot of jurisdictions provide for if they've been missing for over 7 years, then they're dead in, let's say, a wrongful death case. But in a criminal case, you can't make any presumptions. You have to prove that they're dead. You have to prove that they had, malice aforethought for first degree murder, whatever it may be. So that's a right of the defendant, is that every element of the crime needs to be proven beyond a reasonable doubt. Think about an alibi. That's a tough one. An alibi is not an affirmative defense. An alibi is an element of the crime, because if you had an alibi, then you didn't do the crime, and therefore the prosecution needs to prove that there was no alibi beyond a reasonable doubt. That's an element of the crime. Affirmative defenses, think of like self-defense or very commonly insanity defense. So if there's an affirmative defense, the defendant does not receive that constitutional right that the prosecution needs to prove it beyond a reasonable doubt. In fact, the burden can be placed on the defendant to prove their affirmative defense, and the burden can be lowered to clearly clear and convincing, or preponderance of the evidence, or any other standard. So just know that the burden can be placed on the defendant, and the standard of proof does not need to be beyond a reasonable doubt. So affirmative defenses are a different standard than elements of the crime. In Florida, insanity defense is a clear and convincing standard. But on the MBE, it could be anything. It could be whatever the jurisdiction provides for. And the jurisdiction could say the prosecution has to prove it or the defendant has to prove it. Typically, the burden of proving an affirmative defense will land upon the defendant, and the burden is usually something like clear and convincing or preponderance of the evidence, depending on what the affirmative defense is. Installment versus output contract. So an installment contract is a contract that performance occurs sequentially in batches, repetitively. So A is going to deliver, flour to the bakery every Monday, 100 pounds of flour every Monday. That's an installment contract. A cool distinction about installment contracts is that they don't need to conform with the perfect tender rule. There can be an opportunity to cure. So an installment contract, if you deliver 100 pounds of flour every Monday, and one Monday you fall short 90 pounds, that wouldn't be a material breach, because you would be able to deliver 110 pounds of flour the following week, because you have the opportunity to cure. You don't have the opportunity to cure if the facts show that they needed the entire delivery. Like if they say you have to deliver 100 pounds of flour on Monday and we bake all of our bread on Tuesday. Well, if we bake all of our bread on Tuesday, then we would need the delivery on Monday, or else it would be a material breach. So that's an example of when they would not have an opportunity to cure, because it would be too late to cure. But typically there's an opportunity to cure for installment contracts. You asked about an output contract. Output contracts are typically thought of in comparison to requirements contracts. So these are contracts where, again, there's a distinction between them at the UCC, because quantity is not an essential term. Typically, quantity is an essential term of a UCC contract. We need to know how many widgets it's going to be. But by definition, an output or requirements contract, the quantity term is uncertain. So for an output contract, it's pretty much saying that they will buy all that they produce. So if I'm a grocer, I have a grocery store, and I have an output contract with Tommy the carrot farmer, I say I'm going to buy all the carrots that you grow, right? However many carrots you produce, I'm going to buy them all. That's an output contract. Whereas a requirements contract is the opposite. It means that I'll produce all that you need, right? So let's say I am a restaurant, and during the holiday season, I sell a lot more turkeys than during the summertime. And there's a turkey farmer who says that he's going to supply all the turkeys that I need. Well, in the summer, I only need 50 turkeys a week. In November, I need 1,000 turkeys, and he'll supply me with all that's needed. So output contract means that they'll buy all that's produced. Requirements contracts means they'll supply all that's needed. So that would be the, considerations between an output and requirements contract. And then we talked about an installment contract occurs sequentially and has the opportunity to cure. A license versus an easement entitlement. So an easement typically runs with the land, where a license is freely revocable. So thinking of a license, think of like a ticket to the Super Bowl, right? Man, if you act a fool, you start throwing beers around. I mean, not in Philadelphia. Philadelphia, they'll let you do anything, but in a civilized stadium, if you start throwing your beers around, they're going to revoke your license and say, "Hey, you can't be here anymore. You only had a license." A license could be made orally too. Like if I tell my neighbor, "Yeah, man, you could walk across my property," and he hasn't received an easement by prescription, there was no express easement or anything, that would just be a license. And then if he sold the property to C would not necessarily have that same license to cross my property because it wasn't tied to the land. Where an easement is something that's tied to the land. So if there's a easement and it's sold to another property owner, typically that easement will run with the land and the new property owner will also have those rights of the easement. Easements can be, and when you're writing an essay, you want to use all these vocabulary terms. Easements can be affirmative or negative, although typically negative easements are hard to enforce. Riparian rights, water rights are type of easement that is enforceable. But typically the right to sunshine or air rights or rights to a view, those negative easements are not enforceable. Another type of negative easement that could be enforceable would be subjacent, right? Lateral rights. And the question they test on the MBE that's a little bit tough about that is you have to, if you dig a hole under your house and it causes your neighbor's property to submerge, you could be liable for negligence, but not if the only reason for the submergence was the weight of their building. It's only if the submergence would have occurred in its natural state. If the submergence only occurs because of the weight of the building, you would not be found liable. But anyway, negative easements are affirmative easements. Affirmative easements are like the right to cross a property or the right to use a property, right? Um, so there's affirmative and negative easements. There's express and implied easements. Express are granted usually in a deed or via contractual agreement, where implied easements are typically by prior use or by some sort of you know implication reason. So there could be affirmative negative easements, there could be express easements versus implied easements, and then there's easements appurtenant and easements in gross. Easements appurtenant are tied with landowners, a dominant and a servient landowner, and they will run with the land. Easements in gross are personal in nature, where a utility company or a person has an easement, has the right to, put a pole on your property or something, and that doesn't typically run with the land. It typically is personal in nature. So easements in gross, easements appurtenant, express easements, implied easements, affirmative easements, negative easements. And then there's also easements by prescription, which are very similar to adverse possession. It just does not require exclusivity because multiple people could have the same easement, or easements by necessity. Easements by necessity are like if a property has no access to a public road, then they'll have that right to access the public road. There's a lot of things about easements, and how they could terminate, right, via merger or via agreement or release, or different ways that you could potentially terminate an easement. But when you're super in doubt, the easement is likely valid and continues to run with the land. The license is likely revocable, and the new landowner will have no right to that particular license. Elective share. So this is a wills question. Elective share, the jurisdiction provides for it. And in Florida, there's a 30% elective share. Elective share means that you can take 30% or whatever is statutorily allowable. You can take that percentage of the estate upon death, even if the will leaves you out of it. So let's say A is married. I mean, this is Miami, Florida. This is the capital of, I live in Miami, Florida. It's the capital of this. 26-year-old bombshell woman marries a 96-year-old man on his last leg, right? And the 96-year-old man is like, ha, this lady thinks she's going to get uh, my estate. Too bad. I'm going to write her out of the will, and I'm going to leave all of my property to charity, right? Well, the wife can be like, not so fast. I'm going to elect to take 30% of that, and it's the elective share of the entire estate. It's right off the bat. They can get 30%. Let's say the man was like, oh, I like my wife. She was there for me for my last 2 weeks of my life. I'll leave her 20%. The wife could be like, nope, I'm taking 30%, right? She has that. I mean, it could be a husband too, but it's usually a wife in South Florida. They have that right to an elective share. Now, if you have a will and you leave your wife 40%, well, and the elective share is 30%, then the elective share would not be a viable option, right? You'll take the 40% under the will. If the person died intestate, well, the wife would get 100%. So the elective share wouldn't be a viable option. The elective share is when a spouse is left with less than, let's say, 30%, as it is in Florida or other jurisdictions. Let's say it's 50%, 20%, whatever. It's, it's your right to take that elective share out of the estate if you are effectively left out of the will. So let's see. Rule against perpetuities. Okay, the rule against perpetuities means that no interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created. That means that, it's going to apply to contingent remainders or, remainders that are subject to open or subject to total divestment. It just means that we're going to look to see who's the measuring life, who's the last person that could be alive in this conveyance. And is it possible that after that person dies, there's going to be greater than a 21-year period where it's not clear if the property is going to vest or not? Like, if a condition is to any of my sons that reach the age of 30, and there's one kid right now, age 31. Well, that's going to violate the rule against perpetuities. Why? Because it's possible the 31-year-old son dies, then the mother has a kid, then the mother dies. Well, now that kid is 1 year old, and the kid needs to reach the age of 30 for it to vest. So that condition, it's going to take over 21 years for us to recognize if it's going to vest or not. Now, people get confused with rule against perpetuities because it's like 2A, but if A graduates college, then, but if A does not graduate college, then to B. Well, would that violate the rule against perpetuities? You would think it might because, are we going to know after 30 years? But think about it. The measuring life is going to be 2A. And if if A does not graduate to college, then to B. Well, A is going to die. And when A dies, A is either graduated from college, so it vests with A, or A did not graduate from college, so it's immediately going to go to B. There's no time period after A's death where we would have to wait 21 years and then see if it's going to vest or not. So rule against perpetuity is really abstract to understand, I guess. But one tip I have for y'all on the exam is that rights of first refusal will violate the rule against perpetuities. So a right of first refusal means that if a person sells a property and that person retains the right to buy back the property if it's ever sold, that's a right of first refusal. So imagine A to B, but if B ever sells the house, then A has the right to buy it back at its market value. Well, that right there would violate the rule against perpetuities because we could think, okay, A and B are dead. 30 years later, B's heirs go to sell the property. And now, A's heirs have the right to strip it from B's heirs to sell. So that would violate the rule against perpetuity. It's complex, but just see that answer choice and choose it. That a right of first refusal will violate the rule against perpetuities. Really complex topic, but try not to get too lost in the sauce, right? All right. So collateral orders versus interlocutory appeals. Um, okay. So collateral order doctrine is like there's something that's so separate from the case that we need to decide it now, or it'll be too late on appeal. Like qualifying, like a qualified privilege, like if they, were qualified to get a use and derivative use immunity for, compelling statement, right? That right there would be a collateral order. It's separate from the case, and we need to decide it right now, or it would be too late. Um, Things that are subject to interlocutory review would be like a preliminary injunction or the certification of a class action. Those things are immediately appealable. Remember, a TRO is not immediately appealable, but a denial of a preliminary injunction is immediately appealable. So, yes, certification of class action, a um, preliminary injunction, denial of preliminary injunction, what's called an extraordinary writ, like a writ of mandamus or a writ of um, uh, ejectment or something. Those writs could also be subject to um, immediate review. So typically, it's not the correct answer. Typically, we need a final judgment in order to review. And the one they test the most is denial of summary judgment. A moves for summary judgment is denied, and they want to immediately appeal it. There's no jurisdiction for the appeal because there hasn't been a final review. So look for, the collateral order. If they tell you yes, because it's separate from the merits of the case and it needs to be reviewed now, or it would lose its availability on appeal. Otherwise, um, you know, it's going to usually be subject to appeal on a final review. Other things, like I said, denial of preliminary injunctions or certification of a class action, or a qualified privilege or an extraordinary writ. These things could be subject to interlocutory review, meaning immediate review before there's a final judgment. All right. Can statements against interest be made by any available party or non-party? They have to be made by a party. So statement against interest, it does not need to be made by a party or a party opponent. That's a party opponent admission. A statement against interest could be any declarant. It could be, Susie's friend who said, damn, I shouldn't have helped you run away, right? But a party opponent admission does need to be a party opponent, or an agent of a party or party opponent, like an employer, employee, or a co-conspirator, or a partner in some sort of transaction. So Florida essays, what do I think? And the AI slander. Only reason I say that is because it's mostly with the kids. Adults, you guys might be a little bit better at using AI to their advantage, but kids are writing essays using AI. They're doing math problems using AI, and then when they're called to actually explain something, they have no idea. Like, find me a kid that can tell me that x equals negative b plus or minus the square root of b squared minus 4ac all over 2a. I don't think any kid today knows how to utilize the quadratic formula, because you could just type it into AI. And, I think that a lot of times learning things the hard way is the appropriate way, but call me old fashioned. Okay, so Florida essay topics, what do I think you're going to see? Definitely ethics, professionalism. I would say definitely some sort of con law. I mean, it could be Florida, federal, or con crim. I mean, again, that's not predictive, that's factual. There's going to be some variant of con law, and there's going to be some variant of ethics and professionalism. Now, for the remaining four subjects, contracts, torts, property, and family law, I'm predicting, and this is, just based on the fact that property law was tested the last time, I'm predicting that they'll do contracts, torts, and family law. So my prediction is some variant of con law, ethics and professionalism, and then contracts, torts, and family law. Now, does that mean you shouldn't study real property? Absolutely not, because if property is tested, it'll be the toughest essay subject. And I mean, it's a total crapshoot. Anyone out there who's making essay predictions and then taking credit for it, I mean, that's like going to the casino and saying it's going to be black and it's black, and all of a sudden you're Nostradamus, right? Like, don't take too much credit into that, because it's game theory, right? You want to be prepared. If you should either study something or not study something, and it could be tested or not tested, it'll always be proper game theory to study for it, as it will be tested. So I'm not a big proponent of predictive analysis. I think it's actually bullshit, but I'm here to humor you. Okay. A shipment versus destination contract. So a shipment contract means that all you have to do is um put it to the common carrier, right? Most contracts are presumed shipment contracts. So if I'm selling goods to Susie in Miami, or I'm in Miami, if I'm selling goods to Susie in Alaska, all I have to do is put it on the common carrier, and then the risk of loss will pass, because I've done my part. A destination contract, it would say FOB, free on board Alaska, and it would designate the destination city. In that case, if there were to be injury or breakage during transit, I would be liable because the risk of loss does not pass until it arrives at its destination. All right, cool. Yeah, and listen, I'm not anti AI. I'm not anti anything. I'm not anti blockchain. I'm not anti AI. I'm not anti the future. I'm not anti self driving cars. I'm not anti anything. I'm just observant of what it is. And I've seen a lot of students, even for the bar exam, rely on AI a lot and not do well in law school, in bar, the LSAT, and everything. And it's not necessarily because of the inaccuracies. Like that part doesn't bother me. Like, okay, someone got upset because it said Florida was a pure comparative fault state, but it's modified. I mean, you can literally check that in 0.04 seconds, right? If it seems a little bit inaccurate, just verify it with the most updated statute. That's not what bothers me about AI. I think is that it doesn't force people to learn, right? It allows people to have things accessible, but not internalized. And so that's my problem with AI is it's like, I'm a big proponent of memorization, huge proponent. If you don't have Shakespeare memorized, you aren't a Shakespearean, right? Just because you can access, you have the books on your shelf is one thing, but you should be able to recite the poems. To be or not to be, that is a question, whether it is nobler to suffer the slings and arrows of outrageous fortune or to take arms against them, right? That's the type of of knowledge that I believe in. And so I think AI, it just people are like, oh yeah, well, I asked AI gave me the answer, so now I know it. I would push back on that. I would say the real way to know if you know things is a blank piece of paper. I think you're better off studying with a blank piece of paper than you are with an AI machine that has all the answers. Because on test day, you're going to need to come up with the answers internally. So you should be testing yourself like, hey, do I know it all? So I really encourage everyone get a piece of paper out and write contracts, and then write everything out: body of law, formation, breach, defenses, damages. Write out every single defense to contract formation execution. That's true studying. Asking AI what are all the defenses to contract formation execution, and then it spits it right out of you. You read it once and you give yourself a high five. I don't think that's very proper. But here's how you can combine them: get a blank piece of paper, or let's call it a Word document, and on that Word document, type out everything you know about contracts, and then submit that to AI and say, hey, what did I miss? And then it could help fill in the blanks. So that's my recommendation for using, AI is as a supplement, not as the primary mode of studying. And yeah, it's definitely in its infancy. It'll get better in the next 10 years. And I'm not against AI, not at all. I'm not against it at all. I will tell you, I guarantee you, I was the first person in this room to use ChatGPT. I had version like 1.0. I was probably the first person in this room to ever buy Bitcoin in 2013. The last thing that I am is anti technological advancement. I'm just understanding that there's ways of using things to your advantage, and there's ways that things can actually be more of a crutch than of something that'll help you. All right, yeah, 1 week to go, everyone. This was a cool session. I really enjoyed sitting on this tree and talking with you about the law. I'll do something similar tomorrow. Tomorrow will be a testing day, and then I'll do a 1 hour breakdown where I go over some subtopics. So if there's anything I didn't mention today that you would like me to mention tomorrow, I'm more than happy to do it. And please don't take away from this that Andrew hates AI. That's not it at all. Andrew likes passing scores, and I think that you guys need to challenge yourself to see what you know, and that's going to be what's going to lead to success on test day. And also, like we're doing in the boot camp, simulation, practice test, practice test, practice test. Keep doing practice tests, and the ones you get wrong, review them, and then test yourself later on and see if you can get it right. And if you're just learning via correcting your mistakes, that's going to go a really long way. And also, what I did today is valuable. I just talked to you guys about the subjects. You should become the teachers. Pull aside your favorite friend, your sister, your mother, your wife, your husband, whoever. and explain to them the rule against perpetuity. I bet they're going to have some questions. And that's when you know you really know something. I believe this my whole life. You know something when you can teach it to others in a way that they can understand and you can answer their follow-up questions. So I encourage you all to become the teachers and go find some people to teach these nuances of the law. And you'll find that's a very effective way of reinforcing your knowledge base. But I appreciate you all for hanging out with me this afternoon. Tomorrow's another day. I'll be seeing you at 10:30. If you're in the Florida class, Marion and Emily will be teaching family law tonight. If you're in the UBE class, Rebecca will be doing an MBE overview. And then tomorrow we'll have class 10:30 to 3 as always. And then 7 p.m. I'll be doing an MBE review Tuesday, Thursday, and Sunday. So keep up the amazing work, everyone. I'm going to go ahead and stop this recording.